May I please, Your Lordship? I'm moving on unlisted motion, my Lord, for Monday, my Lord, to be listed on Monday. There is some urgency, my Lord. Yes,
What's the urgency?
my Lord, here is the Lokaयुक्त has passed an order without hearing us, my Lord, to charge sheet us, my Lord. We was meeting as a witness, my Lord. Our statement has been recorded as a witness. And 8 of us, my Lord, who was the previous MDCs, we have no role with any corruption or anything. And there is no allegation against of us. Merely because we are a part of the executive committee, my Lord, the Lokaयुक्त has directed, without following the Lokaयुkt Act itself, my Lord, to charge sheet us, my Lord. For that, my Lord, I am before this honorable court. Monday, my Lord. Hello.
May I please, Your Lordship? I beg to mention item number 19, Your Lordship.
You are for?
Petitioner, Your Lordship. I'm praying
Petitioner?
for appellant, Your Lordship.
On pre-meet by the appellant. List is matter up to 3 weeks.
Item number 17, my Lord.
This is that same archery matter where Lordships had inquired whether there was any settlement going on.
Yes, what-
I took
what-
instructions. Our instructions are there's no settlement at the moment. There are no talks on
Settlement talks are at another level, my Lord.
So I'm not aware of that. Not privy to that.
But you should be. You should be instructed.
Because we are instructed. I'm not aware what they are referring to.
In fact, discussion is going on, my Lord.
We have written instructions that they're not aware of any settlement proceedings.
But say adjourn for 2 weeks, my Lord. In the meantime,
Talks at the political level, or so
the
it,
political
it,
level,
it may not be at the executive level. Then.
my Lord, it's a political level, my Lord.
On pre-meet by the respondent, list is matter up to 3 weeks. I think by that time you should,
My Lord. Lord.
come with something definite.
I'll tell them to expedite the thing and come to settlement before that. But item number 20 also I was praying for some time. my Lord.
How long?
Allow for the respondent number 3, my Lord. I'm paying for the respondent number 3.
On pre-meet by the petitioner, list is matter up to 2 weeks.
No, but
My Lord, I beg to mention item number 9, my Lord. This matter may can be taken up some other day, my Lord. Mr. Paul is not present physically, my Lord, so this matter.
I think last time it was Mr. Sen who was not well.
Lordship, I had some medical emergency.
What is the matter about, Miss?
My Lord, here, my Lord, we are challenging an order passed by the Meghalaya Revenue Board, my Lord.
Yes. So, what is the effect of the order? Yes, Mr. Paul.
This essentially, my lords, pertains to cancellation of the lease deed in favor of the petitioner, my lords. The challenge made before the revenue board was rejected on the ground that there is no locus.
Who are you? You are not the.
I am the
lessee.
lessee, my lords. I am the lessee. The present lease deed is in my name. This would require a physical hearing, my lords, which is why my friend is making a prayer before your lordships, my lords. Any date convenient to your lordships, my lords, after a week.
But again, they'll renew the same prayer. They'll seek another adjournment. Lordships have already observed that in case this matter prolongs any further, the interim order will be vacated. So I'll leave it.
Thereafter, my lords, I think both my learned friend
What
and
is the
me
effect of
the?
what is
one order?
what is the effect of the interim order?
There is a statement. The
Interim order
proceedings
was-
are sought to be initiated against them for resumption of the property.
Okay. Eviction process.
Lordships.
My lords, the first issue that then needs to be addressed is whom is my learned friend Mr. Sen appearing for? Because the party, my lords, who is respondent number 2 here, respondent number 1 here, my lords, had expired.
Oh,
And it is our case, my lords, that insofar as the proceedings are concerned, vis-a-vis the respondent number 1, the entire proceedings have abated.
You should have made that submission at the,
My lords, it is
at the
there on
earliest.
record. It is on record.
Has it abated? Any order passed?
Insofar,
I'm not aware
because
where the
app-
submission is coming from.
no application has been made for substitution.
Who is to make the application? The prayer should come from you.
No, my lords, it has to come from the person who initiates the proceedings before the original court. I'll satisfy your lordships on this.
All right, very well. So we'll have it next week then, Manoj?
Next week?
My lords, assuming I have not made an application for substitution, I don't know who is my friend Mr. Sen appearing for then.
My lord, I am appearing for the deputy commissioner who has taken cognizance of the complaint, my lord, and on the basis of which the entire proceeding has been.
And Mr. Sen?
Is the complainant.
For the complainant, Manoj.
Complainant.
The original complainant who's passed away long back.
I'll take instructions. I'll take instructions on this issue, Manoj.
Oh, you don't know that she
the
has
fact
passed?
remains there were several dates which were fixed for hearing. Today, my friend wants an adjournment, and at the same time says I'm not representing the correct party.
So you're
I'll
not,
take instructions. Let
you're
the
not
matter be
aware,
heard.
you're not aware that your client has passed away?
I'm not aware of this aspect, Manoj. I'll take instructions.
It is on record, my lords. It is recorded on an order passed by this honorable court.
I'll take instructions. Let this come up next week, Manoj.
Pro bono. On payment by the parties, this is matter of
As a fixed item, Manoj. As a fixed item.
2 weeks.
When would your lordship prefer to have it, my lords?
So 2 weeks, that'll give you time to check on the...
Well, that's why I'm saying my learned friend is sought 1 week's time. Lordships are fixing it after 2 weeks. My learned friend might not be available again.
No, that 2 weeks is okay, my lords. Your lordship
Then you,
my
you,
have a fixed date.
you suggest on a date.
Subject to everybody's convenience.
It'll depend on my learned friend's
Suggest on a
convenience.
date.
My lords, if your lordship just bear with me for a second.
Today is second.
Well, today is the 2nd of. Could we have it on the
We'll have it on
14th?
the 15th.
15th, my lords.
15 is fine.
As prayed for by the parties, list is matter on 15.
Obliged.
My lord, similar prayer for item number 10 also, my lord. Fix it some next week, my lord.
Mr. Paul is here. What's this
matter-
matter about?
This is the appointment of Gamura, my lord, is in Garo Hills, my lord. This is handled by Ms. B. Kharwal, my lord. She is not here today.
On payment by the petitioner, list is matter after 2 weeks.
My lord, I mention item number 14, my lord. This relating to the signboards, erection of signboards and their removal, my lord. My lord, I am praying if the matter can come up next week, my lord.
Mr. Paul is ready. Why you're...
My lord, I am led by Mr. Senior Counsel, Mr. K. Khan. So, due to some personal difficulty, he is not available today. And I have.
Your lordships have heard this matter on 3 or 4 occasions. My lords, the only issue that then survived was.
Insofar as our contentions are there, my lord, or it is already.
We are only, perhaps if I remember correctly, we are only under relevant rules.
Absolutely. They have to produce the relevant rules, whether Meghalaya has formulated any rules in the first place.
And we are saying that, my lord, there is no such rules, my lord. We are doing in compliance of the Supreme Court guidelines and the committee's guidelines, my lord. And in terms of that, we have acted. And
If it covers your case, well and good.
otherwise, they will have
Excuse me. So 1 week then.
after one.
After a week. Highly obliged.
On prayer made by the state respondent, matters adjourned. This is here after 1 week.
Please, Your Lordship. I beg to mention, Lordship, item number 18.
Yes.
If we may have this matter after 2 weeks, Lordship.
On prayer made by the petitioner, this is matter after 2 weeks.
All right.
Supplement costless item number 1.
Well, item number 2 to 5, my lord. These are revisions against the order of granting bail under the NDPS case, my lord.
Revision.
My lord. Under 439(2), my lord. Read with 482.
439 days for cancellation of bail.
But the respondents are, the notice has to go to, they are residents of Tripura, my lord. They've been granted bail and they've gone back to Tripura, my lord. I'll take steps, my lord. All four matters.
Mr. Dr. N. Musika, DSGI has submitted that this is an application for cancellation of bail granted.
It's a bail appeal, my lord, basically. Appeal against the bail order, my lord.
Yes, but you come against under
439(2).
application under 439, section 439 under bracket 2 CRPC for cancellation of bail. As prayed for, that notice be issued upon the respondent. The same returnable within 2 weeks. Same order.
Same order. 2, 3, 4, and 5.
Item number 6.
Please, Your Lordship. I had already conveyed some offer to my friend, and if it is suitable for them, we can enter into a settlement report.
An offer has been made, Your Honor. I've communicated to my client. We are okay with it. We just have to put it down on paper, my lord. So perhaps on the next date we'll submit a settlement report.
Can it be on 19th, Lordship? 19th of this month.
Learned counsel for the parties have submitted at the bar that tentatively the parties have agreed to settle the matter amicably outside court. However, the formalities of the same could not be completed, and as such, it is prayed that this matter may be adjourned for the day and to allow the parties to file any report in this regard before this court. As prayed for, this is matter on 19th.
Interim may continue till 19th, Lordship.
In the meantime, the interim order pass will continue until further orders.
Item number 3.
Please, Your Lordship, this is an application, my lord, under section 482 CFC. Steps have already been taken in respect of respondent number 2, my lord. But service is still awaiting, my lord. So I may be allowed to, meanwhile, I may be allowed to inquire from the GPO, my lord, whether.
Mr. A.G. Mobile, learned counsel for the petitioner, has submitted that the notice issued upon the respondent number 2 has not yet returned, indicating whether the same has been received or not. It is prayed that the same may be awaited, the report may be awaited. As prayed for, this is matter up to 2 weeks.
3 to 7, Your Lordship. 3 to 7, similar order, my lord.
3 to 7?
Oblige. Highly obliged.
Item number 8.
My lord, in this matter, one of the accused filed an affidavit, my lord, bringing on record certain documents from Northeastern Council.
Or that
NEC.
I think particularly for your accused.
Yes, my lord. My lord, I have sent it to the department. I have not received a comment from them, my lord. So 2 weeks' time is given. I'll just expedite the matter, my lord. What is their view on that?
This matter has come for revision against discharge.
Discharge, my lord. So after we filed, they brought on record certain documents from NEC, my lord.
So if those documents are to be relied upon, then practically the whole case goes.
Exactly, my lord.
Dr. N. Musica, learned DSGI, has submitted that relevant communication, copies of relevant communications have been received. Have you received it from them?
Yes, my lord. I have sent it to department.
Have been received from the respondent number 1 and 2, which may have a bearing on the proceedings before this court as well as before the trial court. However, specific instructions in this regard have not yet been received, for which some time is prayed for this court to be briefed in the matter. As prayed for, this is matter after
2 weeks.
2 weeks.
Item number 12.
Here I have already filed the written argument.
So you have filed yours also.
We already filed your lordship.
All respondents have filed.
Yes, Lordship. Your Lordship, can you reserve it for judgment, Your Lordship?
Mr. K.P. Bhattacharya, Learned J, has submitted that the written argument on behalf of the state respondent has been filed today. Accordingly, since the written argument of all the relevant parties have been filed, this matter is posted for judgment, reserved for judgment.
Item number 13.
This item, my lord, I may require another 1 or 2 days time.
I am praying for some time to file the written argument, my lord. 1 week time.
On prayer made by the parties, this is matter till 2 weeks.
Item number 15.
Yes, Mr. Kumar.
May it please your lordship.
Jima matters.
No, it's not 15.
15.
Yes, what is this matter about?
This one, your lordship, is a criminal revision petition, your lordship.
Or revision?
Filed against the order of 9/10/2018, passed by the learned deputy magistrate, district magistrate.
Yes.
This matter was already heard, your lordship, but just to refresh your lordship, here the case is actually of Nangal Bibra police case, and decided this matter was Jima petition was filed on 28/9/2018, your lordship, for releasing of vehicle. Later on, the petitioner herein has filed one petition that my vehicle has been changed the ownership fraudulently by forging my signature, and prayed before the additional district magistrate to stay the order, as the petitioner has filed another case for forging the signature, which was registered as Nangal Bibra PS case number 17 within bracket 17 within bracket 8 of 2015, your lordship, which was registered under section 467, read with 34 IPC, your lordship. So the learned additional district magistrate stayed the order and passed the order, stayed the Jimma order and passed the order that directed the IO, your lordship, to inquire the matter and file the report in this regard. Against that order, the respondent number 2 has approached the district magistrate by filing of revision petition, and district magistrate has set aside the order of additional district magistrate. So my contention is here, your lordship, that the district magistrate has no power to set aside the order passed by the additional district magistrate, because both are on par, your lordship, and both have the similar power. So if any order passed by the district magistrate or additional district magistrate,
yes, I think last time this court has inquired about the relevant rules.
Relevant rules, your lordship, that under which provision the district magistrate or deputy district magistrate has been appointed.
Yes.
So that is the rule, your lordship, comes that since this matter is pertaining to Garo Hills district, so it will come, your lordship, rules for the administration of justice and police in Garo Hills district 1937, read with the Assam Autonomous District Administration of Justice Act 1960. 1937.
You should have given the list of books. You see,
I have brought book, your lordship.
You should have given the list of books prior to the hearing of the case, so that we can prepare.
Because one already I have annexed that Assam Autonomous, I have annexed with my synopsis, Your Lordship. It has been supplied on the last previous date.
Okay.
And only in 1937 I have brought the book, Your Lordship, here. Page kitna? (93) Take. Come. This will be more of the book here. Rule. Rule 1A, Your Lordship.
1A.
Yes, Your Lordship. Page number 93. I have marked already there.
Yes.
Rule 1A, Your Lordship. The rule for the administration of justice and police in the Garo Hills district. Rule 1A. Power of governor to appoint additional deputy commissioner.
Yes.
The governor may, when he thinks fit, appoint an additional deputy commissioner either generally or for the trial of a particular case or particular cases, civil or criminal, and may direct that such additional deputy commissioner shall, for the general or a special purpose aforesaid, exercise all or any of the powers of the deputy commissioner, Your Lordship. Any power of the deputy commissioner. Your Lordship, now I bother to take the Honorable Court and on page number 99, Rule 22, Your Lordship.
Yes.
This chapter talks about the criminal justice, Your Lordship. Your Lordship, page number 103, Rule 22, down, last one, Your Lordship.
Yes.
Rule 22, provision for appeal to High Court and for revision. An appeal shall lie to the High Court for any sentence passed by the Deputy Commissioner or additional Deputy Commissioner, Your Lordship. This clearly says that any order passed by the Deputy Commissioner or additional Deputy Commissioner,
Yes.
the appeal or revision will lie to the Honorable High Court, Your Lordship.
Yes.
So here the Deputy Commissioner, District Magistrate, who has quashed or set aside the order of the additional District Magistrate, is beyond the provision of law. Only the Honorable High Court has the power to interfere with the order passed by the additional Deputy Commissioner or additional District Magistrate or District Magistrate, Your Lordship. So District Magistrate, by the order dated 9/10/2018, quashed the order of the additional District Magistrate passed on 4/10/2018, is null and void, beyond the provision of law. And as such, I am praying here before the Honorable Court, Your Lordship, to set aside the order of 9/10/2018 passed by the District Magistrate.
Yes. Who's worrying?
Please, Lordship. Lordship, may I bring a Lordship to Rule 22 of the Rules for Administration of Justice, please? May I read again, Lordship?
Yes.
Lordship, Rule 22 states provisions for appeal to High Court and for revision. Number 1. Lordship, may I?
Yes. Over. Yes.
Number 1, Lordship.
Yes.
An appeal shall lie to the High Court from any sentence passed by the Deputy Commissioner or additional Deputy Commissioner. Full stop. Such appeal shall be presented within 30 days of the date of order appeal against, excluding the time required for procuring a copy of the order, provided that an appeal from sentence of death shall be preferred within 7 days from the date of sentence. Lordship, as per my understanding and as per my perusal, Lordship, point number 1 deals with appeals. May I read point number 2, Lordship? Or the Rule 22.2. The High Court or Deputy Commissioner may call for proceedings of any officer subordinate to him, to aid or him, and reduce and enhance, cancel, or alter any sentence, pass, or remand the case for retrial, Lordship. Lordship, as per my understanding, 22.1 deals with appeals, and 22.2 deals with revision. And Lordship, it will be up for consideration whether the additional Deputy Commissioner is subordinate to Deputy Commissioner. Because upon reading again, Lordship, may I? The High Court or Deputy Commissioner may call for proceedings of any officer subordinate to it or him.
Yes.
Lordship. So, Lordship, right now, my understanding is whether the additional Deputy Commissioner is subordinate to a Deputy Commissioner, and if Lordship deems fit and finds it the additional Deputy Commissioner is subordinate to the Deputy Commissioner, then Lordship, the order survives, and if the additional Deputy Commissioner has concurrent jurisdiction as a Deputy Commissioner, then Lordship, the order as per what my learned says is doesn't survive.
So that is your?
That's my submission, Lordship.
May I submit, Your Lordship?
Yes.
I am representing the respondent number 2, Your Lordship.
Yes.
The Zimma of the vehicle was obtained by me. As has already been referred to by my learned friend, learned public prosecutor, provision sub-rule 2 of Rule 22 deals with revision in cases where, in criminal cases, where the Deputy Commissioner or the High Court may call for a record, alter the sentence, or enhance whatever it may be. In this particular case, Your Lordship, when the FIR was filed, against us, the offences which were being triable are to be taken into question. The offences which are triable are offences under sections 406, 420, 384 and 323 of IPC. Majority of these offences, Your Lordship, or if I say all of these offences, are triable by a magistrate of first class. Now, since, Your Lordship, at that relevant point of time when this case was being taken up by the authorities in Bagmara, there was no separation of judiciary and executive. So the officer or the concerned authority who was taking up the case ought to be looked into to be discharging his duty as a judicial officer. If that be the case, Your Lordship, an officer who is trying cases triable by a judicial magistrate of first class, whatever designation might be accorded to him at that point in time, he was acting as a judicial magistrate of first class, first and foremost, Your Lordship. Secondly, the additional district magistrate at that point of time, since he was trying all these issues, keeping the nature of the issues and the nature of his powers, he ought to have acted as a magistrate of first class. And the district magistrate in this case, Your Lordship, being the highest authority there, would act as a sessions court. As a sessions court, as it is inevitable in law that a sessions court will be present in every session or every district, or would be shared by 2 or 3 sessions or districts. Therefore, if we consider this aspect, looking at it from this point, the district magistrate was discharging his duties as a sessions judge, and the additional district magistrate was discharging his duties as the judicial magistrate of first class. If this be taken into account, Your Lordship, as per the provisions of the Code of Criminal Procedure, what happens is that the subordination herein comes into light. The district magistrate in this very case acted as subordinate, the additional district magistrate, Your Lordship, acted as a subordinate to the district magistrate under his powers conferred as a judicial officer. First point, Your Lordship. Secondly, Your Lordship, my learned friend has, from the petitioner's side, has cited all the facts. I will not go into detailed citing of the facts. I'll just cite a few relevant facts. On 8/8/2018, On 28/9/2018, Your Lordship, the vehicle was released on Zimma to the respondent number 2. Thereafter, the petitioner preferred an application and vide an order dated 4/10/2018. The very same order of 28/9/2018 was modified in its essence. Now, if I have to bring your Lordship's attention to that matter, the order dated 28/9/2018, vide which the vehicle was released to the respondent number 2, had attained finality. In respect that order, your Lordship may not find in the petition, since my learned friend has annexed it as annexure A3, but it is not there in the petition.
Annexure?
A3 it has been mentioned, but A3. But this my copy does not contain the order.
Then you should have, if you are relying on it, you should have filed an affidavit, bring that on record. If you are relying on that particular order, now how would this court know what is the details of the order?
That is a difficulty, I agree, Your Lordship. Otherwise, the order was relied upon by the petitioners also.
He may have relied, but
I assume the court's copy might have that order. My copy does not have it.
No, we don't have it.
I was under the impression.
You are referring to order dated?
28/9/2018. In the body of the petition, Your Lordship, the petitioners have marked it as annexure 3. However, the copy supplied to me does not contain it. Therefore, I was under an impression that the copy furnished to the court might contain it.
Anyways, Lordship, even my copy doesn't have that, Lordship. According to my copy, A3 would be order dated 4/10/2018, Lordship.
Yes, that is.
It will be A4. But in my copy is written marked as A3, Lordship.
But the learned counsel is referring to an order dated?
Which is not present in my copy.
28/9.
28/9/2018, Your Lordship.
It's not here.
In the body of the petition, it is mentioned as it has been annexed as A3.
What are the details of such order?
The order, Your Lordship, in essence is that we had prayed for the Zimma, the respondent number 2 had prayed for Zimma of the vehicle, and we were granted the Zimma of the vehicle, and accordingly, that very application for grant of Zimma was disposed of by the additional district magistrate.
So that would be material then?
I have a copy. Pardon?
That would be material. You see, this court would have to go into the contents of the order. Because on the basis of that order, Zimma was allowed. The order
was allowed.
The order dated
28/9/2018.
The records don't go. Yes, I think the records are here. Yes, Mr. Chaudhary, please read out the order.
I'm thankful, Your Lordship. The order states as CR put up today, seen petition under section 451 of CRPC seeking granting of custody of a vehicle which was seized in connection to Nongalpipra PS case number 16/8/2015. Learned counsel for the petitioner submits that the vehicle has been kept in the police station for more than a month and 19 days, and also submits that the maximum period of detention of any vehicle shall not exceed more than 15 days to 1 month. Further, the learned counsel bring to the knowledge of the court the Supreme Court judgment in writ petition civil number 14/2008 in Sundarpai, Ambalal Desai versus State of Gujarat. On considering the fact and circumstances of the case and material submitted before me, I am of the view to release the vehicle BR number AS18A1771 alias AS18A11171 in the custody of registered owner, that is Shri Dilip Kumar Chaudhary, by executing a bond before the OC Nongalpipra. Petition disposed of. The respondent number 2, who is at present the registered owner of the vehicle, was given the Zimma of the vehicle.
Yes.
and the application filed under section 451 was finally disposed of.
Yes, so what is your submission now?
Now my submission, Your Lordship, is that if we pause for a moment and look into the provisions of section 362 of the Code of Criminal Procedure, it states
Yes.
May I proceed, Lordship?
Please.
It reads as, save as otherwise provided by this code or by any other law for the time being in force, no court, when it has signed its judgment or final order disposing of a case, shall alter or review the same except to correct a clerical or arithmetical error. Now, Your Lordship, why I read this provision is that the petition for Zimma was a separate application filed by the respondent number 2, which was finally disposed of by the additional district magistrate via its order dated 28/9/2018. Now, thereafter, upon an application being filed by the petitioners, the learned additional district magistrate passed an order dated 4/10/2018, modifying the same, and not to the extent of any arithmetical error or clerical error, modifying the same, stating that the Zimma of the vehicle may not be granted and an expeditious investigation may be taken into the matter. Why I quote this provision, Your Lordship, is that this application was separately filed by the respondent number 2, and this application was very well disposed of by an order dated 29/2018. And in only manner the court, acting as a judicial officer, could have altered the order is when there would have been a clerical or arithmetical error on the face of it. There is no such error on the face of it. The correction which was made by order dated 4/10/2018 is in terms, if I call recalling the other order and modifying it and not correcting any arithmetical or clerical error. Therefore, the additional district magistrate, while passing this order dated 4/10/2018, in itself had urged to pass the order, and this order is very well in contravention of the provisions of section 362 of the Code of Criminal Procedure. Challenging this very order dated 4/10/2018, Your Lordship, we had preferred, the respondent number 2 rather, had preferred a revision petition before the district magistrate, and the district magistrate, setting aside this order, had passed the order dated 9/10/2018, granting the Zimma of the vehicle to the respondent number 2.
Yes.
This very ground was taken up before the runner district magistrate as well, and the district magistrate, while passing the order, acting as a court of sessions, had remedied the order passed by a court of judicial magistrate first class, which was being presided over by the additional district magistrate, since at that point of time there was no differentiation in between executive and judiciary. This is the second point, Your Lordship. And thirdly, Your Lordship, taking into account the fact that a Zimma of the vehicle is only required for investigation purposes. After the order dated, the impugned order dated 9/10/2018, the state has never come forward or filed any application for refusing of the Zimma. The vehicle was very well granted to the respondent number 2 way back in the year 2018, and the state thereafter has never asked for possession of the same in order to, for the purpose of investigation. So if we are led to believe like that, Your Lordship, it is apparent that investigation did not suffer owing to lack of vehicle, owing to the vehicle being in possession of the respondent number 2. Now, what has transpired actually, Your Lordship, is that there was a business concern between the petitioner and the respondent number 2, and now, owing to the failure of the business, the petitioner is by means of is trying to arm twist the respondent number 2 into giving possession of the vehicle before the court. so that they may reach a settlement. That is all. And there is nothing more lies in the case, Your Lordship. And moreover, Your Lordship, already on an earlier occasion, the judgment of Sundarbhai Ambalal Desai was furnished before this court, and this court took into account the provisions which are made therein, the observations made by the Honorable Apex Court, whereby a vehicle, or for that matter, any article which has been seized, ought to be only kept in the custody of the prosecution till the time its custody is required for the purpose of investigation.
What is the
Otherwise, the custody.
Have you cited that authority? Who has cited the authority?
Yes, Your Lordship. A copy was also furnished to the court on an earlier occasion.
Just give me the citation.
2002-10 SCC.
Yes.
Page number 283.
And para?
Para numbers 18 and 21 would be relevant, Your Lordship.
Yes.
In this case, as well as various other cases, both the Apex Court and various other high courts have held the seizure of the vehicle or the custody of the vehicle by the prosecution is only necessary to expedite the investigation. And once that has been done, and the whereabouts of the vehicle have been located, photographs of the vehicle have been obtained by the prosecution, then when the vehicle is no longer required for the purpose of investigation, the vehicle may be returned to the registered owner, and the registered owner, Your Lordship, in this very case is the respondent number 2. Now, I must concede to this fact that the petitioners thereafter filed a separate FIR before the Nongalpipra police station, which was registered as PS case number 17. This current case is PS case number 17 of 2015, whereby they had made allegations that the transfer of ownership in the name of the respondent was made through fraud and forgery. That again, Your Lordship, stands to be proved before a court of law, and the requirement of the vehicle in that case for the purpose of investigation was never sought for. The vehicle was only seized in connection to Nongalpipra PS case number 16 of 2015, which is before this honorable court today, and the said vehicle was released in the year 2018. Now, to turn back the clock, Your Lordship, and ask for the vehicle back into the custody of the petitioners would itself defeat the very purpose of granting a Zimma in the first case. So, Your Lordship, there are majorly 2-3 points. The one point, that the additional district magistrate was discharging his powers as the judicial magistrate of first class, and therefore the district magistrate, while passing the impugned order, was acting as a sessions court and had every power to try the case under revision.
Mr. Chaudhary,
Second, Your Lordship,
Mr. Chaudhary, as far as the status of the additional deputy commissioner is concerned, deputy district magistrate, you have asserted that he has, in this particular case, he has acted in the nature of a judicial magistrate in the regular course of things.
While passing this particular order.
In the regular course of things.
Yes, Your Lordship.
Now, where is that reference from the record? Where is the authority, or where is the assumption of such function indicated, from the papers, that the particular ADM has assumed jurisdiction or taken it upon himself to conduct this case as a judicial magistrate or as a magistrate for that matter? Is there anything from the records?
There is no particular statement to that in any of the orders, Your Lordship.
So you see, what you have, that is only an assumption, or it could be a surmise, because what you have to look into is look at the papers, look at the order. The order was clearly passed by a person who addressed himself as the additional deputy commissioner, additional district magistrate.
District magistrate.
So now that nomenclature has to be taken at face value. And why we are saying this is in the
True, Your Lordship, that one-
in the context of the relevant rules, which says that the additional deputy commissioner, the power of the additional deputy commissioner for that matter, is concurrent with that of the DC or the deputy commissioner. So
yes.
you have to look at it from that angle. If you can, if you can point out to this court definite instances or precedent where yes, the said officer had acted as a magistrate, then you see, for all we know, he has passed the order as the ADM, I believe.
True. ADM.
So if that is the case, then the law rule is very clear. Rule is very clear. One thing is the order passed by the ADM cannot be, set aside or cannot be taken up by a court of the deputy commissioner. That is very clear. If that is so, then, at face value, the appeal order will not stand. But I mean, subject to your contention on this aspect, you have to convince this court only on that aspect. The rest, you see, the rest will not matter. We are here confining ourselves to the facts and circumstances of this application here. As far as the nature of Zimma, why the vehicle is not required, so on and so forth, that is not the issue here.
The moot issue, Your Lordship, is whether the ADM was subordinate to the deputy district magistrate or not.
Yes.
If I have understood it correct. Your Lordship, if I may refer to the language of Rule 22.
Mr. Chaudhary, if you go through the rules, you'll find that officers who are subordinate to the deputy commissioner or the district magistrate for that matter are the assistant to the deputy commissioner.
True, Your Lordship. That is there, Your Lordship. That aspect might require some examination, Your Lordship.
No, that's the scheme of the rules.
Otherwise, if Your Lordship, that is. Otherwise, Your Lordship.
Yes.
If I may refer to sub-rule 2 of Rule 22, it states that the High Court or the Deputy Commissioner may call for the proceedings of any officer subordinate to him, to it or him, and reduce and enhance.
So who are the subordinates?
That is a provision for revision, Your Lordship.
So who are the subordinates? Like I said, only the assistant to the deputy commissioner will be subordinate to the deputy commissioner.
Will be subordinate to the.
But not the EDC, because it's very clearly, you see, I mean, the rules are very clear. They hold concurrent power. For example, see, for example, you see, let me give you cite an example. We have in the district court, let's say for instance Shillong, where the 1937 rules are applicable. So we have the district judge. We also have the additional district judge. But here, the additional district judge, for some cases, or rather for the sake of jurisdiction, has also been conferred with the power of the additional deputy commissioner. In that respect, he acts independently. His function is akin to that of a deputy commissioner. In fact, here we do write the nomenclature as deputy commissioner judicial under bracket. That's beside the point. But the fact is that the district judge or the session judge will not traverse into the jurisdiction of the additional district judge or the additional deputy commissioner. You got the point?
I understand, Your Lordship. Your Lordship may kindly allow me some time to deliberate on this point.
What is there? Anyway.
Otherwise, it's clear in the rules.
If you can satisfy only to that aspect, that whether the additional deputy commissioner was in fact functioning as a magistrate at the relevant point of time, that in that case you do have a case. but from the face of the record doesn't appear. How long? 1 week.
A week's time, Your Lordship.
So we'll give him the time.
Right, Your Lordship. Then also they don't have case, Your Lordship, because I am the registered owner there.
Whatever the case, we are not talking about.
I have filed the additional
Mr.
affidavit
Kumar,
also.
we are not talking about the
Yes, Your
the
Lordship.
fact that you are the registered owner or you are the owner of the vehicle. That's beside the point. The fact is that the vehicle has been seized, and the vehicle was eventually, released on Zimmer.
Yes, Your Lordship.
That's all.
Until date, Your
And
Lordship.
the fact is that it has been released, as you said, to a person who is not the registered owner. That is a different thing. But we are on the. We are on the legal aspect of the matter.
Yes, Your Lordship.
As far as the power of the EDM or the Deputy Commissioner or District Magistrate is concerned.
Your Lordship. Even like after separation, Your Lordship, from executive to judiciary, notification was issued 14 December 2020. There also clearly says last two line, Your Lordship. Additional Deputy Commissioner shall, for the purpose of aforesaid, exercise all the judicial powers of the Deputy Commissioner within the said district, Your Lordship.
Give him a copy of this notification.
Already have given. They have, Your Lordship.
You have your your colleague here with you, Mr. Chaudhary.
I have a copy, Your Lordship.
No,
Yes, Your Lordship, I have a copy here printed on the last date.
Yeah.
I have a copy, Your Lordship.
On pre-made by the respondent number 2. This matter has been substantially heard. However, in course of hearing, the learned counsel for the respondent number 2 has sought for some time to seek specific instruction. Accordingly, the matter will now stand posted to the next date. Let's see after 1 week.
1 week, Your Lordship.
1 week.
After 7 June, Your Lordship, if possible.
Fine.
Very well, Your Lordship. I have no objection.
Item number 16.
Thank you.
Much obliged.
Yes.
Lordship, the conducting counsel is on sanction leave.
They have not
Lordship, may
mentioned.
kindly take up this matter after 2 weeks.
Had he mentioned hour you should have sought for adjournment?
We got instruction late, so that is why.
I am for the respondent number 5, Your Lordship.
On pre-made by the petitioner, seeking adjournment on ground of personal difficulty. This is pre-made by the learned counsel for the petitioner. This is matter after 2 weeks.
Obliged, Lordship.
Deeply obliged, Your Lordship.